This morning we are in the market. This is AM Live. My name is Gladys Gachanja and we are focusing on intellectual property. Well, this conversation came out of a conversation we had earlier on SMEs, and one of the issues that came up as a huge hindrance to SMEs thriving is actually intellectual property, the knowledge of the same or the lack thereof. Well, to delve deeper into this conversation, I have with me in studio Peter Oloo, CEO, Social Enterprise Society of Kenya, SESOC. Thank you for your time. Next to him is Marsha Aida, who is a science and technology law lawyer. Thank you for your time. Daddy Owen, gospel music artist, who is also the former board member at the Performance Rights Society of Kenya. Thank you for your time. And we have Liz Lenjo, who is an intellectual property lawyer. Thank you for joining me this morning. Now, looking into the internet, trying to figure out what intellectual property, what it defines for me is a creation of the mind, such as inventions, literary and artistic works, designs and symbols, names and images. It gives a person certain exclusive rights to a distinctive or type of creative design, meaning that nobody else can copy or use that creation without the owner's permission. Now, for the layman, that does not make a lot of sense. So I'll start off with you, Liz. Please break it down for us. What is IP?
Okay. So what you've just mentioned is like umbrella of what intellectual property is. So intellectual property is divided into different facets because it protects the creations of the mind and the expressions thereof. So depending on how you express your idea, there's a different way the IP law would protect you. So for example, literary and artistic works would fall under copyright. Copyright protects the expression of an idea. So which means we can have so many ideas that are similar, but it's how they're expressed that is different. So that's why when you watch soap operas, you will see storylines tend to be the same, but the execution is different. And that's what copyright allows. Yeah. The same thing with drawings. I can draw a cow differently, and Daddy Owen will also express it differently, but they're two separate drawings. Yeah. But it's a cow. Yeah. Then there's patent, which is the most commonly abused phrase that we're always telling people, you need to patent your idea. Now, patent is the highest form of protection, and it's accorded to innovations that are new, novel, and industrially applicable, which means they have to have some sort of use in the industry, and they have to be, novelty means you're the first person to have created it in the whole world. The threshold of a patent is so much higher, and it usually takes about 2 years. So that's why, because the different IP offices have to communicate. So here you'll have Kenya Industrial Property Institute. Once you lodge your application, they will, distribute your application to uspto, which is the US office, to the EU IPO for the EU region, Australia, and all these offices will have to communicate and confirm that there is no what we call prior art, that no one has done it before, basically. So that's what a patent is. So we don't patent ideas, we protect the expression of ideas. Okay. Then we've talked about now designs. So how you create, how beautiful, whatever it is you have created, if it's furniture, if it's, I don't know, your phone, for example, to be protected by what is called industrial designs, which protects the aesthetics, the aesthetic elements of it, not the functionality, but just how beautiful it is. So the textures, the colors that you achieve, the shapes, maybe even to some extent, the print as well. The print as well is very common, is what you will also protect. So that beautification aspect is what is protected. Then we have trademarks. Now, trademarks protect the brands that we create. So these are the names, the symbols, the colors to some extent, the made-up words that we come up with, the slogans and whatnot. Yeah. So that is what we protect under a trademark, and you can get what is called exclusive use, however, to the extent in which you use it. So, for example, if I sell diaries, yeah, then there's a specific class for products made of paper. So that's what the class I would pick and say, I'm in the diary business, I make booklets and whatnot, so my brand name will only be exclusive as to that class. So which means that, say, for example, I do nation printing, but then someone else decides to do nation shoes. They can coexist because we are not directly competing, and the likelihood of confusion is much lesser. And also I'm using a common word, nation. Yeah, so unless I made up my own word and I make it obvious that I actually came up with this word, it does not mean anything in any other language, so then it's exclusively mine.
Wow, that is a whole lot to actually comprehend, but we will break it down even as we continue to have this conversation. Now, to the other lawyer in the room, Marsha, when it comes, your field is science and technology, and of course we are living in a digital world, and a lot of ideas are out there, and many of them are being picked and people are running without really giving due acknowledgement to the authors of those ideas. So what are some of the loopholes in your area?
First of all, as Liz has explained, the most common misconception is the idea that, oh, I have this idea, so I want to patent it. Everyone is like, oh, I need to patent this idea, I need to do this. But first of all, you cannot essentially protect an idea, because everyone has an idea. What you protect is the expression or the execution of that idea. When it comes to science and technology, it usually translates into probably lines of code, or particular content creation for the digital world, and some things of the sort. So what you need to do, first of all, is to find a way to express this idea, put it in writing, like go through the proper channels, and then now you can actually apply for intellectual property protection. A common loophole is people talking about it, sending emails. Like, the first disclaimer is, do not share your ideas through emails or anything of the sort. Do not already publish an idea without seeking protection for it first, because now it's hard to go back and claim it once you've put it out there and you didn't protect it.
Okay, now I'm confused. You said you cannot patent an idea, just the expression of it.
Yes.
So like, if I actually send it an email, have I already expressed it because it's in writing?
Yeah.
Is that what you mean?
Yes, and then you've already put it out there. So now it's so hard, you can't claim it back.
Okay.
Yeah.
Now slow down on that that thought, and I get to the SMEs. And Peter, I'm sure you've grappled with the same, saying that you're an umbrella body for social enterprises and social entrepreneurs. What are some of the issues you've come across in as far as ideas are concerned?
Yeah, okay. Thank you, Gladys, for the invite. I just want to break a myth, you know, and even take us through the issues with intellectual property. I think many of us are aware of the Shonda, how it came, and the story how it went. Yeah, so we are social entrepreneurs. We are not only SMEs. Many of us are SMEs, but also we have the corporates, which are also social. Because if you look at big corporates like Unilever, Safaricom Foundation, they are social enterprises. But let me go back to your question. The issue here is that the lack of information to SMEs. Some believe that, you know, getting intellectual property or to patent your idea is really very expensive. And that is what we tell them, that it's not expensive. Once you have an idea, go out there, go to keep and apply to your idea to be protected. That is one thing. The other thing is about, you know, just like my friend here said, is about you throw an email to somebody, I have this idea, and then you find that idea is already taken by somebody. So it begins by you not giving the disclosure to anybody. You need just to maybe have a public meeting, maybe in a room like this, share about the idea, but don't express it in terms of an email or maybe something like that. It's good to speak it out in a meeting, but not really doing it in form of writing. Yeah.
And you have found many who are going into business have been, you know, literally curtailed by the fact that they share the idea way before they even put it to life. It happens
every day, even today, even yesterday, even many years back. Look at the innovation hubs we have. You know, young people from the university during holidays, they go there, sit on their laptop, and, you know, you talk about this. Or maybe the hackathons that go around. I'm not saying that the hubs are stealing ideas, but what I'm saying is that you can see somebody coming in town and saying that a hackathon. So people are hacking an idea. Then now, after that, everybody goes his way. Then you find that the same idea is renamed, given a different name, but it has already been picked. Yeah.
Okay, now to the music industry, where copyright is the one name that you hear over and over again. Now, Daddy Owen, this has been a pull and tag when it comes to performers.
Yes.
For you, when the moment you have the song in your head and you go into a studio, at that point, how should you protect yourself?
That's the trickiest part, because sometimes there's a song I recorded a long time ago. I didn't release the song because the person who came to do like background vocals went and recorded the song. Because for me, I was recording because I was working on a project. I was like, in the next 6 months or in the next 1 year is when I want to release a full album. You know, an album consists of 8 songs, 12 songs, or 18 songs. So all these songs, it takes time for you to record. You can't record a song today and release tomorrow. Okay, I see nowadays young kids doing that. But for us, it was like, you must record a song for like 1 year. 1 year, you finish an album, and then you're planning now to launch it. So the problem was, while I was recording the song, this person who was doing the BGV to the song went ahead, recorded the song in another studio, and released the song. You understand? So my worry was, should I fight this battle with this young person, or should I just say, let me go and leave this song and drop it and record another song? Because the thing was not clear. For how long should I, okay, after I've recorded it, should I register it immediately, or should I keep it and register it as an album? You understand? Because the problem is, some people release songs, some people release projects. There are people who today they record a song and they release it as a single. But for us, like as I speak right now, I'm recording an album, which I'm planning to release 2019. What if that person who comes to the studio to play the guitar, listen to the song, and sell their idea to another person? Understand? So that's the other trickiest part that so many artists face in this country.
Okay.
Yes, and apart from that, even after you release the song, the common problem that we face, even Liz knows, is when the song goes to the market, this song will go to the market with different names. Because the issue I had one day is, my song title was System ya Kapungala. Let me give you an example.
Yes.
So the people who are selling the song, they divided the song into like 3 types. The first title was System ya Kapungala. The second title was Kapungala. You understand? So while they are selling System ya Kapungala, of course they'll give you the revenues for System ya Kapungala.
Yes.
But the Kapungala one, they'll retain the, you understand? They'll retain it. So when you go to ask for stats, they'll show you System ya Kapungala. Of course, that's your song. But they know what they're doing. So there's so many loopholes that people are exploiting, which if we start talking today, we'll not even finish.
All right, we'll touch on them even as we go ahead. Now, Liz, answer one of the questions. At that point, when do you register your song? When you release the song, a single, or when you've done your whole project and protect it as a whole?
As soon as you have expressed it, protect it. You do not need to wait to do a compilation of some sort. As soon as you've created it, and especially when you have concerns like the ones that the Owen has, then it's prudent to immediately go and register it. And it's not an expensive process. Without a lawyer, you can do it for about 1,500.
Oh, really?
1,000 to lodge the application and 500 for a commissioner for oath stamp. The documents are online on copyright.go.ke. So it's just about now seeing the application form and how you will fill it. And then there's what we call the statutory declaration, where you have to swear that it is actually your true property. So that in case now you are lying, then there's some legal liability towards that.
So in his case, when the other person went and released the song, the same song, would he have had any mileage or any advantage if he went after them legally?
Yes. You see, the thing with copyright, registration is not a must. It's a recommendation, yeah? Copyright is inherent from the minute you express it. The minute it's just somewhere tangible, you've written down your lyrics, you've gone into studio and you recorded something, and there are people who can actually say that the Owen came here and we hummed this song and he wrote the lyrics and I recorded. That's enough. He did not even need a certificate of registration. As long as he has some good witnesses and some evidence at least to back him up, that's all he needed.
But I guess the question at this point would be, how do you prove who was the original author of the idea?
Whoever had it first would show the record. So if probably he typed it from his laptop, what we call the digital rights management information would show that this document was typed on this day. So that would help one of them. Maybe if he had a pen and paper and he wrote the date, that would also be used as evidence.
So you need to actually record when it is you penned it and keep the records of the same.
Exactly.
Okay, now to Marsha, maybe at this point you can explain to us, what is intellectual property rights? What does that mean?
Essentially, when you talk about intellectual property rights, is just the right to protect whatever ideas and the literally works you have put out, the expression of in writing. That's the right to use the property, the right to gain from it, the right to monetize it, the right to share out the property, and of course, the right to profitably gain from the property. That means you have exclusive rights to this idea. You can dictate how it is to be used, how it is to be shared, how it is to be sold in case of resale or reuse value, which is another system of its own.
Yes.
But you have essentially rights to the property. Yes.
Okay, so
Like
in the case where Liz is saying the moment you have your ideas expressed, you don't necessarily, for example, a song, have to go and register it. But for me to actually have the kind of rights you're talking about, I do have to register it for me to have all those rights, right?
Especially in the digital world, you have to. You always, what she's saying is true. As long as there is some sort of, like, at least you can give evidence. There is a digital proof footprint. There's a timestamp of whatever you've done, so it can be proved that this was done earlier, prior to whatever else is coming up. As long as that is okay. But when it comes to digital innovations, lines of code, content creation, stuff like that, it's really essential to register and actually have it with you. Because most of the time you find there's so many loopholes that can be that you make available if you do not register for it. First of all, you're subject to claims, third-party claims. You're subject to other people saying that they have the same thing. A lot of people sit on a lot of ideas. You'll find that a lot of people actually expressed that idea but didn't register it. So it's like a race. Anytime there's something, like, for example, the Uber system right now, there's so many apps providing like taxi drivers and whatever. So many people come up with the same ideas all the time. So it's a race to how you've packaged the idea, your execution, and it's a race to register that specific expression of how you're going to do your thing before someone else does it.
Okay.
Yeah.
It's a race for time, literally.
It's actually a race. Even in stories, like she mentioned, so many soap operas are out there. And they usually have the same storyline, give or take. But the way you've expressed your story and everything, it's a race, because you don't know. You might be thinking about this story right now, but somebody else is also thinking about the same thing. So the minute it's actually a race to actually go and register. You have to be, it's first come, first served.
Okay, now, Peter, when you look at it from the business point of view, I mean, the best example would be Mama Nyanya comes here, the next Mama Nyanya takes over, and there are a whole list of Mama Nyanyas who are selling the same thing. And that has happened in business also. So how is it that people now can, maneuver that to ensure that they actually keep what's theirs and actually profit from it?
Yeah, I mean, it all goes to the legal instruments that are there. And I think Liz had it very right. First of all, it starts by you understanding what exactly are you doing. For example, I'm in IT, apart from running Social Enterprise Society of Kenya. So if I come up maybe with a mobile application that is trailblazing out there, and, maybe we want to compete Uber or Taxi and all these. So it depends on what is it that you want to differentiate. How do you want to differentiate yourself in the market? And then if you have realized that this is very unique, this is something that I want to really, really move and differentiate from what is there, then it's good to protect it right from the beginning. And as Lisa said, it's very cheap. The only problem that many entrepreneurs is that they think that protecting an idea, IP, the talk out there is that the process takes, like, I don't know, very long. I think as it has changed the list, if you can confirm that. You just go to online. I think for patents it's from IP3. You download it, fill it, you submit to Kenya Industrial Property Institute, and then now the process starts. So once you have that unique idea, the best thing is that it's not bad to share your idea, because you also need to help you to craft it and do it. But then as you do that, I talk about it, start the process. Yeah.
Okay, Liz, before we take a short break, you said it only costs 1,500. Maybe you can explain to us how simple this process is so that we can bust that myth.
All right. So that was copyright registration. Yeah, copyright, you don't necessarily need a lawyer as long as you understand what it is you're protecting. However, the danger of not using a lawyer is you can easily try and protect a concept. Then if on the Kenya Copyright Board side, they're not, either they are swamped and they're not able to comb through your work well, they'll grant you a certificate. So however, when there'll be a dispute and there'll be that argument whether or not it was actually an expression of an idea or a concept, and of course if you're on the concept side, that certificate will be revoked. So that is usually the challenge of not using a lawyer. Then we have the trademark process. The trademark process takes about 6 to 8 months. Again, depending on your product, your business goals as well, what are your long-term plans? So if today I'm planning to sell shoes, then tomorrow I'm planning to sell, I don't know, food stuff, for example, and I have a clear process in which I want to do it, then a lawyer will be able to tell you, what, when now we start registering, you have at least up to 2 years to use the other classes that you're yet to use, so that then they guide you, so that at the beginning, on the onset, you protect everything at once. Because also with trademarks, as I had said earlier, because there are certain classes, someone might decide, oh, this guy is just only selling shoes, I'll go into the food industry and use the same name. So then, because in the beginning when I was registering, I did not foresee that my name could easily go, I'll lose it. So then I lose what is called the priority claim. I cannot say now, because I had already been using it, you have to give me back my name. Yeah. So that becomes then a challenge. And then trademarks also will vary with the statutory fees will vary with the number of classes. So it can be anything from 16,000 to whatever. 60,000 is just for one class. Then of course there would be legal fees when you retain a lawyer, and you're able to do that. I always say use a lawyer because it's easier. 6 to 8 months can be a long time if you don't know the process. A trademark is divided into the search phase. There is the examination, the application phase, then the examination phase, then the gazettement phase. And then during the gazettement phase, there might be an opposition where someone is saying, no, please do not grant this trademark because of the following reasons. Then you need your lawyer again to help you with that process, to navigate it and see how fast we can secure that trademark. So of course then using a lawyer becomes a challenge. A patent, as I said, takes about 2 years because of that whole communication, but there are interim measures, provisionary measures that can be undertaken, but you need that one, you need a lawyer for sure. You cannot do it by yourself, so that you understand what you need to have in place in such a situation. Industrial designs take about 4 to 6 months at most, so which means then your drawings and all these fancy things that you have created, you immediately launch them. Yeah, and especially with designs, the minute you put it on social media without protection under the Industrial Property Act, you lose your claim automatically. Yeah.
So this fad that we see people trying to market their goods, and somebody goes and picks up your design and runs with it, just because you never protected it, you cannot stake claim.
Yeah, it becomes very difficult because the act is very clear. The minute you share it in the public domain and you have not protected it for designs, I'm sorry, it's a wrap.
Okay. Oh, well, I think we will do that soon as we come back from this break, because a lot of questions already coming through, especially one to do with music, and Daddy On will also speak on the same. Who owns the copyright in recorded music? The pull and tag between the artist and the producer. Well, that conversation continues right after this break. Stay with us. Good morning. Thank you for staying with AM Live. We are in the market, and our focus this morning, intellectual property. Still with my guests this morning, Peter Oloo, CEO, Social Enterprise Society of Kenya, SESOC. We have Marsha Aida, Science and Technology Law Lawyer. We have Daddy Owen, who is a gospel music artist and also a former board member at PRISC, and Liz Lenjo, intellectual property lawyer. Now, your comments, your questions coming through on Twitter, Gladys_Gachanja at NTV Kenya. And somebody, Abdallah Mdambo, actually says, underinvestment, ineffective management of intellectual property rights, and rampant piracy have prevented the industry from realizing its economic potential and left its artists struggling to earn a living. Before we went to break, Peter, you wanted to add something.
Yeah, I wanted to add something. Many entrepreneurs think that once you own, you get the copyright certificate or patent certificate at the end of it. The thing they also entrepreneurs need to know is that you go an extra mile and have legal agreements in terms of disclosure. Yeah, so it doesn't end by you having the certificate from Kipi or you getting, something that a piece of paper. It goes an extra point of view as you do your business. Then you need to have legal agreements in terms of what you need to disclose and what you don't need to disclose. I just wanted to add that.
Okay,
Yeah.
which is important, and
Yeah,
maybe
yeah.
why Abdallah is saying there are many or ineffective management of intellectual property rights, and if you do not know what to do to protect yourself,
Yeah.
of course you'll have to face piracy.
Definitely,
And
definitely.
speaking of piracy, Daddy Owen, as an artist, this is something that you have to live with, and times are changing with the digital world. It's getting worse in trying to, arrest some of these issues. But let's first start off with, when it comes to copyright, between you and the producer, who owns this idea?
First and foremost, we need to define that word producer. That's where the challenge starts. Because
Yes.
I think there are musical terms that we inherited, and maybe they work differently here in Kenya. Because even in Kenya, when you say a track, people think a track is instrumental, the instrumental part of the song. But if you ask Liz, will tell you a track is the song
Itself.
You understand? The song itself is called a track. But if you ask many artists, will tell you a track is the instrumental part of the song. A producer, we always term people. How can you put them? Are they arrangers or? Are they? They're not composers. Because
Out here.
I think I'm a producer.
Yeah.
You understand?
Yeah.
But if I tell someone right now I'm a producer, they'll be like, no, we know RK is the producer. We know Ogopa is the producer. We know, you understand?
Yes.
There are people who are known to be producers.
Yes.
But for me, if I tell you, I went to the studio, I wrote the song, I arranged the song, I composed the song, you understand? I performed the song. I paid for that person who was singing those keys,
Yes.
who we call the producer. That's where the challenge starts, because I know even right now the Producers Association are ready to call this studio and say that the Owen, the fight starts. So a song consists of author, who we call composer. You understand?
Yeah.
There's a arranger, there's a performer, and then now you can add the publisher. Because there's, like, let me give an example of a song called Vanity, one of my songs. Vanity was written by Pitson. You understand?
Yes.
I was just a performer. A performer is the person now who is behind the microphone to record, what we call recording. Now we did the recording of the song. So I put the vocals on the song. And then I arranged the song, because I was like, I need these girls to come from here, enter here. I need Jumatutu to come and play a saxophone. I need JJ to come and play the guitar. All these things. But I still need Jackie B.
The producer now?
Sasa ndio, yes.
We demystify
Yes.
under the law. So in music we have copyright and related rights. So the copyright itself is the authorship of the song. Now when we're writing a song, there can be different parties that can own copyright in the song. There will be the author who writes the lyrics, the composer who creates the melody from scratch. Then
That
the
is what Daddy
arranger-
Owen is.
Yes.
Yes.
Then the arranger who decides how the song shall, whatever.
Uh-huh.
And in some instances, these three people can be different people.
Okay.
And when they are different people, they need what is called a split sheet, which is a very simple document that says Daddy Owen, composer, Liz, Peter, like that. Then we say, yours is 20%, mine is 50%. And we have that conversation. And that conversation must happen even before we record, because we've already rehearsed before we go into the studio, because the studio time takes it's money. So we have that agreement before we go into the studio, because if we do it after the fact, agreeing is going to be impossible.
I can imagine.
Yes.
So in that list, do we add on this producer guy,
So
the guy who
we're
now
going
give
slowly.
it, give,
We're going slowly.
Okay,
Yeah?
we're not yet
Yeah,
there.
we're
All
not
right.
yet there. Yeah. Then in some instances, I decide I want a publisher who's in the business of making money from, help me make money from my music. They will be entitled, because a publisher will market the songs and then maybe get advertising revenue. My song will be used to advertise AM Live. Then I make some money. So then the publisher will take a cut and a copyright. Then in the related rights, we have the performer, and then we have the producer. So we start with the performer. The performers would include the singers, the instrumentalists, the track producer, because in this instance, as he said, under the law, a track is more of the instrumentals. It's someone on the bass, someone on this. And because of now technology, those fancy things you see in the studio, they do everything. They've sort of replaced instrumentalists, so to speak. The background vocalists as well are performers. And then now we also have actors who will be in the music videos, and the dancers as well. They fall under that category of performers. Now, the producer under the law is the one who puts in the money. Yeah. Now, unfortunately, with our industry,
I pay for the song.
He will pay for the song, but the mistake that the Owen will do,
Yes.
he will not say, okay, Liz, I've come to your studio. Here is 15,000. I want to own the master recording. Here is a contract. Because it has to be in writing. So that is the challenge our artists are facing. You know, we are too gentleman, quote unquote. We just have this gentleman agreement. Hey, we got her, and we're like, yeah, dude, it's we are working together. So then when money checks in, they're like, boss, that 15,000 you paid is not enough for you to own the master recording. However, if we had a contract and we had already signed,
and
he's not going to go back on his word and say, no, Daddy Owen, apana, you don't own,
Okay, so Daddy Owen, what has been the issue here?
The biggest issue is that word producer. So many artists go to the studio, and this guy called a producer demands for money before we work on something. You understand? So you pay them. Nowadays, imefika paka 30,000. You pay for the payment of 15,000, and then you start working on the song. But for me, since I met Liz and Liz demystified all these things to me and other organizations, I discovered, for lack of a better word, the moment I pay you, it's like work for hire. For lack of a better word. Because at the end of the day, it's like you're claiming, if I give you 30,000, I've bought your rights.
You're working for me.
You're working for me. You understand? And they always claim it's not studio time, because you'll pay them that. And in that, they'll say, this is studio time. This is the money for the studio time. You understand? Out of the 30,000. So it means I'm not paying for, because studio time, I need to pay for the studio time, of course.
Separately.
Separately. Because sometimes most of these producers, what we call producers, don't have their own studios. So you have to go to Tabosusa and ask for Tabosusa, hey, can I use your studio to record this song? Get the point?
Yes.
So the moment I'm paying for studio time is separate from what this guy will do. And what this guy will do is the same as what I'm going to do, because him is a creative. The same as I am. Because, you see, the difference is, I can't play those keys, but I know how the song should start. I'm the one who created the song, how it's written, how the intro will be done, how the ladies will sing, how the BGBs will do all these things.
So essentially the author of idea.
Yes. And I have everything, all the elements of that song here, how I'll do it. The only thing is that I just don't have the expertise of playing the G clef, F clef, all those things is what I don't have.
So clearly it would be prudent if you protected yourself with a contract from the get-go to ensure that you do not have this muckiness that comes with producer versus the talent.
The problem, okay, I always say the fight is we need to educate our musicians and to define and demystify all these things. And even the producers, because when you raise this topic, everyone they want to fight. They are like, no, we are the producers. We own the studio. I'm like, we're not fighting. Even me, I'm a producer. It's only that I don't have a studio. It's only that I don't know how to play all those keys and all these things. But I'm a producer. If you use that term, I'm a producer as well. Yes. Because I pay for my own song. I arrange my own song. The only thing is, you come in a different right, like what Lisa said, which we always embrace that. When we thank God, because everyone is talented in a different way. I can't do all these things. You understand? But we need to define now, what do you own? What do I own? How is it going out there? And the moment it goes out there, all these fights come when the song becomes big.
Yep,
you never hear this fight with this small song.
Yes.
But the moment the song becomes big, it's always a fight.
Everybody wants a piece of it. Now, Marsha, speaking of which, he touched on copyright for hire. Now, are there exceptions when it comes to copyright? Like, if I am working for you and I come up with an idea, whose is it? Mine or my employer?
Again, I go back to the point of contracts before everything.
But in this case, you're employed to generate ideas for a company.
That belong to the employer.
To the employer?
Yeah.
Oh, wow.
Because even if you're working, especially, let me put it in the digital world, let's say you're working on your laptop and you're employed to this company that's doing this application or something. And whatever you see that, oh, I can make this easier. Maybe there are complaints, or traffic on this site is like this. There's a way I can make it easier. And you come up with that, and it really even sort of changes the way, the direction the application is going, or something of the sort. That's not your idea. The rights to that, whatever you've come up with, are not yours. They're for your employer. And that's why even as what he said, that when people assume that once you have the IP certificate, you have the protection, it's a go. It's not. There are so many other legal agreements that come afterwards.
But in the case of where you're employed, and your job is to ensure that the job you do is done to the maximum and done in the most efficient way, how do you protect yourself as an employee who brought in an idea that is actually earning the company you work for millions?
Usually there's an employee agreement that has to be signed that actually dictates that whatever you come up with in the duration of this, and sometimes it even goes towards, even if you are let go of that employment, maybe it gives you like a competition clause, like maybe even 5 years or 10 years from now you cannot use something similar to what we're doing here. Some of them go to that extent. As a person employing you, when you get into that contract or that agreement, the only thing, and maybe it will just dictate, is maybe you get a commission out of it, maybe you get paid, maybe for contributing to an idea that's actually growing the business, but you do not own rights in that idea.
Truth of the matter is, the most you will get, Peter, is a pat on the back for helping the company make the millions.
Yes.
So how does it look like in the corporate world?
I mean, the stories have been there out there. You know, many companies now have even started innovation departments. You know, so that, because let's look at the banks. Banks are now being disrupted with this, you know, the digital transformation. So they've realized that the only way to beat that is to really innovate around their business products. So in the corporate world, I'll agree with Marsha that once you get the employment, for example, you are going to be the head of innovation in a company. They normally tell you that you need to sign particular documents that whatever you innovate around the company products belongs to the company. But you see, you could be having your side hustle out there. Some people do that, you know, maybe doing some other things, innovation and drawing code and that. So when you do that out there, not related to company products and services, that one you can own it. But related to company, you know, operations, company statutes, or company products or services, that belongs to the company.
Okay, so all you're doing is adding value to the company, and a pat on the back will do.
Yes.
All right.
Another thing, if I may add, is like he's saying, if you're out there doing your own thing that's not related to the company, and another good thing is to always lean on disclosure. So it's good to disclose to your employee that I'm doing this on the side. It has nothing to do with this. So that there's not this issue of, oh, are they using our technology to do this? Are they doing this? So it deletes the whole suspicious thing. So disclosure is key. Yeah.
Though at times it can work against you.
Yes.
Okay, so it's a risk factor in itself. Okay, now, Liz, now that they're talking about you could work for a company and probably be tied to the fact that you can't use that idea even after leaving, meaning there is a timeline to copyright, right? How long is this? And is it different from the industry?
Okay. So another thing to consider when you're talking about the different regimes of IP is how long you own it. So with copyright, you'll own it for your lifetime, then plus 50 years after death. So which means once you pass on, your next of kin will benefit from it for 50 years, and then after that, it reverts into the public domain. With patents, it's 20 years, with the flexibility of that plus 2 years, the 2 years during which the examinations were being done. So after the 22 years are over, it goes into the public domain, and anyone can now use that technology or that innovation, improve on it, and work on something else and commercialize without seeking your permission, because your years of exclusivity are now over. A trademark is renewed every 10 years. An industrial design is up to 15 years, after which it reverts into the public domain. But there are strategies you can also employ to maybe even transition now into a trademark if you plan to use it in the long term, in terms of protecting the designs. Yeah.
Okay.
Yeah. So, and now in instance of employment, I always tell people that you can negotiate. When you know your value, you can negotiate. That contract is not solid. When people tell you, oh, that contract is standard, it's a lie. If you know your value as Gladys, you'll be able to say, for example, I created AM Live. I know this thing has the following, you know, potential. So should I ever leave NTV? I want 50%, you know? And then you have that conversation with your boss and they say, you know what, actually, Gladys, perhaps stamp. So should you leave, you can still benefit and people will always also remember you as the author. When you asked about the rights copyright grant, there's also what we call the moral right of attribution, that you will always be recognized as the creator. And in Kenyan laws, that is one thing that the law cannot take away from, even a contract. So despite it even being a work for hire, I will always be known as Liz created this software, or Liz wrote this song, even if Daddy Owen was, you know, commissioned me to write the song for him. Yeah, but I'll always have that right as to be remembered or to be known as the owner, or rather the creator. Yeah. So attribution is also one thing that we've seen so many companies trying to take away that attribution right from authors, which is not right. Yeah.
Okay, now, Daddy Owen, you mentioned earlier you had a pull and tag about the name of one of your songs when it came to the rights to it.
Yes.
And at this point, I think that's where we ask, can now names or titles be copyrighted in the case of the music industry? If you go with System ya Kapungala, as you said, and then the Kapungala guys are also making money on the side, how do you now come out and say, the original was System of Kapungala, so I am also, or I should get money off of these other ones on the side?
Is something that we're just discussing with Liz off air about an artist who right now has made a lot of money because he had a song. Did he trademark the name?
Okay, let me help you.
Yeah.
So you see, we do not copyright words.
Yeah.
If you want exclusive recognition of a word or a name that you've made up, then you need to trademark. Then you get that exclusivity. So like for him, he should have now registered System ya Kapungala as a trademark. Yeah, and then he also, now for him, the weakness was the contracts, the distribution contracts he went into. He should have said, if you're going to use my song, you must tag it as System ya Kapungala on whatever platforms you use. You shall not say Kapungala, and should you decide to do that, it's still my song. Then he registers System ya Kapungala as a trademark, and then they might ask him, what does Kapungala mean? Then he says, I made up that word because it's a mishmash of somewhere words from Lingala, blah, blah, blah. So it's a new word. So then he has exclusives. Everyone knows Kapungala, Daddy Owen.
So I can copyright a name.
So you trademark.
The problem here is,
okay.
Yes.
you see, these things are easier to be discussed now. But you see, those days, someone came and told me, Owen, I want to set your songs on mobile phones. You're like, how will you set my songs on? You see, it's 2002, 2003.
Then things were not the way they are. Yeah.
These people already know that in 2018, smartphones will be like 60% of this country. You understand? They've already forced you as an artist. You're a creative. You don't look at these things to this level. You understand? So they're like, sell us your song. So you just sign. You don't know what they're. You're like, us. You're the masters of River Road. Yeah, we know how to sell these songs physically. Yeah, so you can't beat us. Right now, we are fighting with those cartels who are selling music in River Road. You want to sell our songs on mobile phones. How will you even hack it? So you are not even bothered. The problem is, so many artists, we face that because even right now, we are selling so much of our songs online, and we have like so many online companies which are selling music. Okay, they're not even selling. You can download the songs for free on their platform. They're giving our songs out for free on their platform. So you're like, 5 artists, you're saying, no, us, we can't. 57 artists are like, aye, for me, as long as the song is out there, everyone is getting my song, my song is becoming popular, I'm getting shows. That's how it works for me. You understand? So it's different because there's Mdundo. With so many people, it's like they're selling your songs not to the value that it really deserves to be sold. You understand? But it's a channel that is out there. Every DJ nowadays, if you go to a show, they'll download a song from there. which is a good thing, because even me as the day when I imefika show na nimesahau my CD, I know DJ John will download from Mdundo immediately and play my songs.
But what you're saying, it's a double-edged sword.
It's a double-edged sword, because the problem is, you as an artist who've been in the industry for many years, you know your rights, you know the value of your songs. You're like, how can you sell my song to people with this at this value? But young artists are like, I don't need one song a year. I need 15 songs. Out of 15 songs, if 5 become hit songs, I'm a household name, I have so many shows, I perform every weekend, then what's the big deal? As long as my songs are out there, I'm getting shows. That's how music is working. So it's changing. It's really changing, because right now people are doing music to maintain their name. They're not doing music to be paid out of the song itself.
Yes.
It's like an advertisement. It's just to maintain your brand. If you ask someone, how much do you make out of this song? They don't know. Kitamo used to know. Nowadays they're like, as long as my brand is out there, every month I have a song, my brand becomes big. That's what matters. Not the song. Not the product, but the brand.
So I guess there's a lot of compromise also when it comes to making money off of this. Marsha, let's talk about social media. The music gets to us before it's even released from the studio, so you download it. Literary works. By the time Michelle Obama was releasing her book, some people had it on PDF. I mean, and the story goes on and on. So how exactly can you protect yourself? Yes, social media is good for your marketing, but then again, how do you ensure that you make every single shilling out of it?
Social media is just a pain, like if you think about it. It's crazy. Like he said, it's double-edged. You want your brand out there, but then again, it's so hard to mitigate social media. It still is, as long as it's been around for a while right now, but it's still hard to do it. So you find, like, in this new age, just to lean on what he just said as I get into that, is that in this new age, you find even musicians, they're trying to figure out and invent new ways of how to capitalize on these new avenues that have been created. Yes, your songs are available and they're being streamed basically for free out there. So what else can you get? What are the other perks you can get from this? So that's when you get into maybe assignment agreements where you actually like give up like a song for something, or like completely, like that's you relinquish rights to the songs for that purpose. Maybe you get into licensing agreements where you have specific things where you have licensed your song for this amount of period, maybe to cover this, maybe to do this. We're looking for endorsement deals because you're trying to build your brand. Yeah, so you're actually trying to create your music in a way that it fits to whatever is out there. So you can find other ways to benefit from this and benefit from a social media following. Yes. So when it comes to literary works and everything of the sort, you just have to be smart right now. You have to figure out how to capitalize right now. Because if you can do the most to protect by getting your certificates right, you can get your agreements right. But again, you'll always find that social media will take it and go with it. So you have to figure out how you can do, like, how to further exploit your own invention. Like if it's a book or whatever, you figure out how it can work for you. Because that's the thing with social media. You just don't let it go like that. You have to figure out how will it work for you. Does this make you get into more speaking agreements? Like you have engagements. Does this lead you into maybe talking to producers, turning it into a movie? Like, because of social media, let it work for you. Let it push your name forward, and then work towards that. And but important before you do that, like you said, don't just release things out to social media before you have actually protected it. Because all these things I'm talking about, like licensing and assignments or anything else you're talking about, you can only talk about these things once you are registered and you have proof that you own the rights to that property. Yes.
Now, before we move on from that, let's talk about the publisher when it comes to the book. How do you make sure that they don't hide behind this murky world of social media and ensure that they do not release your book before you let them do so?
Can I help her with
that? Yeah. Anybody? Yes.
So, because I have worked with several clients in publishing and their authors. So generally, when you get a publisher agreement, They would have a strategy on, when release is planned, the kind of strategy they have, the marketing and whatnot. So we'll find if you have a publisher and in instances, because self-publishing is almost impossible, it's expensive. By the time you print a book and it's almost impossible. So you're better off getting a publishing house that can do that for you. But when they do that, they sort of tend to be in control, maybe 90%, because they also can argue they understand the market, they know when to release the book, they know who to print with best, all these things.
You mean when you self-publish?
No, when now you have a publisher.
A publisher,
yeah,
okay.
When now you have, you've gone into a publishing agreement. And because they undertake a majority of the costs, actually, most of the time 100%, apart from maybe you wrote the book, but then they'll figure out the editors and whatnot, all those other things they will take care of, book cover design, typesetting, they will take care of. So because of all those costs, then they tend to run the show. So for you, it's now when you're having that agreement, once they have reviewed your book and they say, oh, we can work together, then now you look at that strategy that you have for yourself also as an author and figure out what do you want and how can you then negotiate. To what extent can you be in control? Now, unfortunately, most of our authors don't realize or they don't have a strategy. So then they leave everything to the publisher. Then halfway into the agreement, they realize, oh, actually, I would have done X, Y, and Z. I could have capitalized on my previous success. I could have done these things. But it's too late. You already signed on the dotted line. So then the publisher decides the when, the how, the which. You just show up, sign books, look pretty, and wait for your check.
At the end of the day.
And also to add just a bit on that is usually it's about strategy. Like I said, when you're dealing, especially when you're dealing with online, so you find that maybe publishers or whatever, they will try to sneak in maybe snippets of the whatever they want to publish. You find there are just sections of the book out there. Maybe it's just a strategy to just get it known that this is coming out and this is what the interest, gathering interest or something of the sort.
Like teasing the market.
Like teasing the market. So you find like you had mentioned earlier that Michelle Obama's book Becoming was already out there. People knew sections, or she's talked about this, or she's talked about this. But maybe it's just some whole strategy.
So it can be a marketing gimmick.
Yes.
Okay.
So that's the idea. That's the thing with social media. Even with music, you can tease. Like he's saying, he wants you're working on an album. A lot of people use social media. You just tease a lot on it. You find people are doing an Instagram story in the studio, and you just put one line out there. Okay, of course, after you've already protected it. Then it's a way. That's how you can get ahead with social media. Right now, you try and get ahead of it.
Still getting a lot of your comments and questions is another one from Alex who says, great, I like the conversation. I think patenting has derailed many creative minds. Registration of ideas will ensure originality and ensure upscaling. Speaking of which, Peter, we have an issue right now. We're pulling and tagging over this statement, Hakuna Matata. So in this case, something that was a Swahili word that became an in thing and somebody has taken it elsewhere and is running with it and saying it is mine. How now did we even get there, and how do we protect ourselves?
I think as Liz Lenjo put it, you cannot protect words, right, Liz? Yeah, but you can protect a brand. You can protect an idea. But then, Hakuna Matata is a Kiswahili word. I really don't know because I'm not a legal person, but then I don't know if you corrupt it and say, Hakuna and make it one word and say that I own it. I don't know, because if you also hear, I don't know what was the Kabarak name. I read something in the newspapers that former President Moi has gone to court, and I don't know whether they have already protected Kabarak.
You can't use it, yes.
Yeah, so Hakuna Matata, from my own non-legal mind, I don't think you can protect Hakuna Matata. But I also wanted to add something related to that. We in the industry, there's a lot that we need to do in terms of awareness and training. Because the issue of IP, intellectual property, look at that entrepreneur in Lodwa. He has an idea, he could be a farmer, he could be running a kiosk, he could be doing anything. But then, he doesn't know which channels to follow. So I think both the media, both our city, the lawyers and everything, there's a need of really coming away and creating a lot of awareness in terms of how do I protect my idea. because many people just know maybe copywriting. So if you have like a logo, you'll hear somebody saying that, how can I copyright a logo, which is not right. With logos and names, it's about getting a trademark. Yeah.
Okay, speaking of which, Lisa, maybe you can enlighten us on this one. Right now, we have Walt Disney saying they are trademarking this. How did we get here, and was there that loophole that we actually let out there that Walt Disney ran with?
So I'll tell you this, in my legal opinion, there's no legal loophole. Like I said, trademarks protect the fancy way of using words to protect a brand. So what Disney did is they probably had people come to Kenya back in the 90s. They came and did a safari, saw animals. They would hear that song, Hakuna Matata, and they're like, oh, does it mean no problem? Oh, interesting. We do a script. Pumbaa says, Hakuna Matata.
Yes.
And it's happening. Now, it's a very smart strategy for Disney, because what they did, remember I talked about trademarks and protecting in certain classes. It has to make business sense for you as a company. So for them, this is an animation. Our audience are children and probably adults who love animation. So how do we push sales for this movie? Let's go into merchandising. How do we make sure we protect ourselves in this instance? Let's register the brand under Class 25 for clothing, headgear, and footwear, so that as we push the movie, we are selling T-shirts, we are selling shoes, blah, 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 and no one will compete with us and have Hakuna Matata for that specific class. And they were smart. They said, we shall register only in the US, because in the US, it's where it is different, it feels fanciful, it makes sense, yeah? If they had done that in East Africa, guys would be like, Hakuna Matata, why do I need a T-shirt written Hakuna Matata? Or shoes? You know, for us, it's a common phrase, it's whatever. And even when you look at brands in Kenya, different brands, we have ice creams with Italian names, Amore Mia, we have Daily Nation. These are English words. What is the genesis of English? English comes from German. So now if you look at the conversations we've been having on social media and this bitterness we have, then basically we would also, if we are saying we want to get paid for Hakuna Matata, then we have to pay the Arabs, the origin of Kiswahili. Yeah? So language is a tool of communication. If we are going to get over far-reaching and over-complicated and want to own everything, then even the body of public knowledge will die. It will mean every time I want to do something, I must seek out a license, because now we're going to the extent of knowledge. Yet we have been pushing for Kiswahili to be recognized as a UN language. Now, being a tool of communication, seriously, what are we saying? Are we saying that everyone then will be paying everyone? Because everything inspires everything. So we need to be very clear and stop getting things skewed, yeah? And we agree, you went to Italy, you found new words, and you come back and you say, oh, I'm going to start a restaurant called Amore Mia. I went to France, and I want to start a makeup brand, maybe Raison d'Etre, and we move on. And you see, even when you look at even the English dictionary, they borrow words from different languages. You'll see French, you'll see some Latin, you'll see some word. So there's this cohesion that we need to also now realize as Swahili-speaking countries. And Kiswahili is now spreading. South Africa are now pushing for Kiswahili to be part of their system of languages. So, I mean, language, to be fair.
All right. So, Liz, are you saying, before you comment on it, the fact that they have trademarked it does not mean they stole it from us? Because that was the headline.
Yeah.
Walt Disney steals from Kenya.
Has it stopped us from using Hakuna Matata? Has it stopped us from speaking Kiswahili? Because people are speaking in the context of now they've taken everything away from us, but they haven't. It is only to the creative aspect in their jurisdiction. And they said, oh, Hakuna Matata here is different. It's unique for our brand. It makes sense. I can actually attach a value. Even to assess it becomes different. Yeah? But I mean, it's not taken away from us. And just before she adds something, I will say even in the local context, we have 42 tribes. So just because I'm a Taita, does that mean I can't brand my business with a Kikuyu name or a fancy Kikuyu name or a Luo name and whatever? You know, are you saying then I have to pay the Luo community for calling my brand Nyadi, for example, you know? We need to start asking ourselves these pertinent questions and realize we're going into a place where we'll decide now doing business will be impossible.
Okay, knowledge is power. Marsha?
Yes, and you've said you've reached into what I wanted to say. But then again, when we began this discussion, we said intellectual property rights. We are actually protecting an expression of that idea and how it is executed. So you see, that's what they did with Disney. They went ahead, they got these two names, Hakuna Matata, and then the way they've expressed it in the movie, they've expressed it in their merchandise and everything. Their execution is unique to that way, and that's how they've trademarked it. Anybody else could do that the same. You could come up with your own phrase, and how you express it, how you put it towards your business. What attachment of value does it give you in commerce, like commerce value? What commerce value does this give you? Like, for example, maybe even just advertising gimmicks. Like maybe in Swahili words, the advertisement for, what is it, super loaf. They said, usiseme mkate, sema super loaf. Yeah, never say bread, say super loaf. You see, that's already like something that's trademark worthy, because it's a phrase. But then they're just normal language. They're just normal things we say every day. Yeah. So yeah, that's what it is. Essentially,
Okay, to you, Daddy Owen, when it comes to music, and definitely your industry comes with a lot of mass production to make the sales and what have you. Non-disclosure agreements. In the case now that you're coming up with an album and you want it to be released the next year, and have you released singles in between, or you want this to come out as an album?
I want it to come out.
Have you explored that route to ensure that we do not have the music out before issued? And is this something that now performers are aware of to protect their property?
Okay, there's so many performers who right now, okay, I think last year but one, we did a lot to make sure that we had forums, seminars and all these things, to just call on artists to come together and at least understand what do you need to do before you release a song and all these things. But at the same time, there's still these loopholes whereby you feel like we always record so many demos. Before you call something an album, there's so many demos you record. And you feel like, if I start registering all these demos, because right now, since like 3 years ago, I've recorded like more than 30 songs. Out of these 30 songs, I think I want to make sure that 10 are the ones that I'll release out there. So I want to explore that route that Liz has brought here of 1500. It's just ringing on my mind. The 1500 ringing on my mind. It's only 1500
for every idea.
1500.
Yes.
So after this, I'm with Liz here and there to make sure that the 1500, this goes with the 1500 to make sure that all these, because to me right now they're still demos.
Yes.
You can't call them like full tracks, and those are the things that other people can exploit and make sure that they use what was yours to end up, you hear out there and you're like, oh, why did I do this? So it's good insight, and I think we need to do more. We need to do more, because there's so many upcoming artists out there who have great ideas, and the worst thing that happens is someone can come and sing an idea for you, because we had that story with the Sauti Sol. They were in a cab, and this cab guy is a musician, and the cab guy was like, I'm excited to see Sauti Sol, and he was like, I want to be a musician, but right now I'm still looking for money to go to the studio. So he sang an idea to Sauti Sol, and Sauti Sol, this guy claims that after that, the song they chucked was his song. But there was nowhere to confirm, just what Lisa said, there was nowhere to confirm that that was his idea.
Okay, which makes sense with what Marsha, you were saying earlier. A group of friends sit together, you exchange ideas, and you say, if I had the opportunity, I would do this. Then somebody hears the idea, and actually because they have the resources, they make it a reality. Then when it becomes a hit, what now happens to the original guy who shared the idea?
Again, prevention. Prevention is everything. Like when you already, that's what I was trying to say. Like people can just be sitting even in a bar, or people are just seated elsewhere, or maybe even just us over here, and we're thinking about, this is something that's already there, but let me just use it. Or would it be nice if we could just order like medicine and it just arrives? Like honestly, like some stupid thing like that, and somebody's like, okay, I'm a techie, I can do this application or something like that. But they didn't come up, they're just doing the application. But so these other two people came up with the idea.
Yes.
And then he's like, okay, so can we do this? Let's get into business. And they're like, no, it's okay, I like my job. Let me keep doing this. You go ahead and do this. So the issue comes when now this thing takes off. It takes off and you hit it big. And now these people can claim They can be there like, oh, so we were together when we were fixing
Yeah,
this thing.
I
So
gave you the
where's my
idea.
cut? Yeah. So now they're suing you for money that's a lot of money. So the best thing is prevention. You sit down, get a lawyer, and you just disclosure. We sat down, we came up with this, and now I want to go with this. So according to this agreement, let's do this. If it kicks off or something, let's agree that you'll get maybe 5% of this and this, because I'm going ahead with this. When you have that in writing and you have a lawyer present and you have everything sorted, even when you hit it big, somebody can't come back and be like, oh, you left me out, or you did what? Like, no, you knowingly signed this. Another problem, again, is where we think we know, but we don't know. Let me put it like that. Like, you've done your own research on how to protect your rights and everything. Then you find yourself, with this generation, we want to make money quickly. So you have this idea, you've made this script or something, and you approach these houses, because I've had this story so many times. You go to probably like a net or something, and you have these ideas, and you want to whatever, and they tell you they're going to commission your story. And they just basically buy all the rights to your story. And you're okay because you're being paid. You're like, oh yeah, it's good money, you've been given money and everything, and you've not really looked through that agreement properly. You think you're getting your rights worth, but no. And you get paid one-off. Then you find that this movie of yours has actually been airing for the last 10 years. What revenue are they getting? You were paid one-off. So you see, you can't come back and claim that because you've already commissioned it out. So sometimes you have to be able to think about future value. Like, just don't be so willing to sign off. There's so many stories about people who had very good applications, sold them out, just like that, one-off. Yeah.
Just in the search for quick money. And I
Yes.
think this is such a big reality in the business world, Peter.
Yeah, as I said, my background is also in tech.
Yeah.
And I've happened to visit some of these tech giants. I can tell you, Gladys, many innovations come in an informal setup. Let me share what Google does. You know, Google encourage, in Google headquarters in the US, they encourage, like tea break. Google has done a research and said that best ideas and best innovations that you see in Google don't come in boardroom meetings. Best ideas actually happens when you are taking tea, or maybe when you are driving home. But now the challenge is, and this is where now maybe the legal people can help us, is that you share an idea when you are driving home with a fellow staff that, you know what, I've been thinking of doing blah, blah, just to change the way we do things in our company. And then somebody overhears that and jump away with it. So that is the area that is really a challenge. But the thing is that we in the business world, best ideas, best innovations, we have realized that it comes from not in a boardroom meeting and discussions going on. It comes from a very simple, look at Facebook. I think you know how Facebook started. Mark Zuckerberg was it in Harvard? They were just they were sitting in the dorm, and then Mark said, now, these university students, how can they interact and do A, B, C, D? Okay? And you see where Facebook is. There was no formal meeting about that.
Yeah.
But then we need to really know, once you share that and say that this is what I intend to do, how do you protect that from there? Yeah.
That's what's of importance.
Yeah.
Now, Liz, when it comes to fair use, there's some quote and quotes in as far as how far that can be used. Please explain that to us, because we've seen instances where something is copyrighted or trademarked, but for some reason you are given leeway to use it to a certain extent. Explain that.
So fair use especially applies in copyright, and it's an exception to exclusive rights. And it's very clear in our Act, and even in other jurisdictions, to what extent is it free. So in the context of education, you're allowed to, talk about the way Google works. We are allowed to sample some music in a music class and dissect where, how did the author come up with these songs and whatnot, educational context. Criticism, you want to write a news piece, you want to talk about, Google or Nation and how they do their business, or whoever, or Dasani. Because that's a trademark that's been protected, but you're trying to share some criticism, you're trying to share some news piece, then you have that legal leeway to be able to not call, you know, Coca-Cola and say, oh, I'm going to write about Dasani. Can I use, you know, you don't need to, because you're in the business of disseminating news, you're giving your criticism, you're giving your comment and whatnot. So parameters around which are fair, basically. You're not going to unlawfully gain. So you're either educating the masses or you're sharing information. That is to the extent, in summary. But our Copyright Act is very clear. We tend to get a little carried away and say, oh, you know, if I use 5 seconds of Daddy Owen's song, I think it's free. No, it's not. The minute I hear that melody and I know it's Daddy Owen's song, you must have gotten the permission from the owner. If it's not yours, you must get permission from the owner. You must clear it.
And speaking of which, Daddy Owen, we are living at a time where cover songs have become the in thing. Is that an infringement of copyright, or is that okay? From an artist's point of view, before she gives us the legal point of view.
Just help us.
No. But for you, do you think it's a violation of your hard work, or do you think it's also a way of marketing your song?
You see, those are the loopholes I was talking about. There are people who think it's okay, my song is famous, now my song will become more famous. But there are people who are like, I love my art so much, you're infringing my rights. You understand my point?
Yeah.
Because there are people who will not talk to you, and they'll do your song. But others who, of course, the discussion, and then they pay you, or there's a discussion of how the revenues from this song will do this, and you understand, there's a discussion before what will come out. But that's one of the loopholes that I've seen in the industry. And the second one is a collabo. The moment me and Liz work on something, let's just use this scenario. Liz right now wants to become a musician. She's like, okay, I have a song and I want to feature Daddy Owen. The biggest mistake Liz does, of course, the notion here is Owen is famous. Owen is the moment guys will hear this song I've done with Daddy Owen, they'll rush, they'll say, I want to play the song because Daddy Owen is famous.
It will push the numbers.
It will push the numbers. But the problem is, the moment we do a collab with Liz, I'm the one who will become the biggest beneficiary of that song. How? The industry where it's going right now is more about the brand. So the more I check out music, the more my brand becomes bigger. I'm the one who will get more shows more than her. Understand? So for me, I'll continue performing this song even to events that she can't access. Or maybe they just said, we want Daddy Owen to perform at Jamhuri Day celebration. For me, I'll go as Daddy Owen. There, when I reach there, the organizer will say, hey, that song that you've done with Liz, wow, that's the whole song. You must do that song. So for me, I'll perform that song.
Yes.
But you see, out of all that, Liz is not benefiting anything, because the music right now, like I said, it's not about the product, it's about the brand.
Yes.
People pay for the brand. People will pay for this brand because it's a bigger brand. Even if they don't have a big song, but it's a brand that people can relate to, will pay this brand. So the collabs, so many upcoming artists are doing that mistake, because you can't blame me for performing that song, because that's a song that everyone wants me to perform on that day. Liz can't come and blame me. But the problem is, out of my shows, maybe in January, I've performed that song like 10 times. And Liz, no one has called Liz anywhere to come and perform that song.
So you're the one pocketing all the
so
money.
So I'm the one pocketing all the money.
So Liz,
I don't know how that loophole, I don't know how to cover that loophole.
Okay, Peter?
Yeah, I think there's this issue of business modeling. And I think there's also need of us in the entrepreneurship space to encourage, you know, whether you are in music, whether in what, to really understand your business model. Because look at LinkedIn. LinkedIn, you join, you do that, but then there's a point whereby you have to pay. Same with Facebook. So you being given some airtime, or maybe going to perform in a presidential function, in a way, that is a way of marketing you. So once you know your business model the way it is, because we have what is called freemium. You say that I'll do it for free, I get the market, I get the adverts. Yeah? So once you know how your business model runs, then you can never worry. If it is part of your business model that I'll do some of these things for free and get the advertisement and get the exposure, cool.
Okay.
Yeah.
All right. Now, as we close, I'll start with you, Marsha. give us tidbits of how we can actually protect our intellectual property. Earlier on, you touched on the fact that please do not put it on email and send it out. What are some of the other things that you can do to ensure that your idea does not come mass market?
First of all, when you have an idea, think about essentially how you want to represent this idea or present it, how you want to execute the execution of this idea. You have to really think about that very well, so that by the time you are actually expressing this idea, because you have to express it in writing, when you're expressing this idea, you don't leave anything out. Because sometimes, most of the time, you start off with an idea, and maybe that idea has room for growth. So you actually express it in this way, then you lock yourself out. And maybe when you start doing the thing and you start getting into other areas, like maybe Liz mentioned, you can trademark and say, oh, you want to trademark plus merchandising, plus this, plus this. So you make sure you have covered, like, to the utmost extent of what you feel like that idea can. Of course, you could come back and revisit, but at the first instance, really think about your idea in that
So
process.
seal all the loopholes.
All the loopholes. Think about it well, express it well, seal everything that you can think of at that point. Second of all, do your research. Figure out, get a good, like, what's happening, where to go to. If it's copyright, Kekobo. If it's trademark, you know, just figure out where to go to, have the right, figure out how much it will cost, what duration it will take, everything. Another thing, and I said this before, do not email, do not, before you have actually expressed this idea and you have it covered, do not talk about it, do not do anything about it. Do not share even with a potential partner or a potential investor, like maybe you're trying to look for funding. Do not even share it through email or anything. Always make sure you have a scheduled meeting, and preferably go with an IP lawyer. So that in case there's anything that comes across in that meeting, or there are any agreements, it can be mitigated in that meeting. So you see, that's something that's already documented. That's like a way, you know, you have to think of how do you protect yourself. Yes.
Okay, I will leave it at that. Daddy Owen, the performers have been fighting for their rights for a long time, and you've learned your lessons along the way. What are the tidbits you can leave them with?
The most important thing is just for us to become more knowledgeable, because as creatives, people say creatives are lazy, but we're not lazy. It's more, it's more like we are wired to focus on what we know. That's our biggest problem. We focus on, I'm a musician, I love music, I want to stay in the studio and learn more and do that, and that's what I want. At least people like Liz, who came to the industry and started to give us more knowledge about how you protect your music, how you protect your rights, and how you can move forward. As because every now and then music is really changing, and how you're selling the music is really changing. The platforms, the opportunities are so many. So the most important thing for any artist right now, in fact, mostly upcoming artists, to make sure that at least they have the knowledge on how you should protect your music and how you should protect your products, so that when they go out there, at least you have a bargaining power when something happens to your product.
Okay, and Liz, it needs an IP lawyer, and as just listening to you, as much as it's only $1,500 to register for a copyright, retaining a lawyer is an expense in itself. Not everyone can afford this, and especially those startups. So are there avenues that people can, you know, attach or plug into to ensure that they survive?
The first thing I always say, ask and ye shall receive. Yeah.
Okay.
Every engagement is subject to an agreement, to you know, conversation. Yeah. So I always say, if you're going to invest in beautiful clothes, then invest also on the legal side of your business. Yeah. Because it's the framework that will put you together.
I wanted to add something
now.
very fast.
Yes.
Yeah. So the other way is that, of course, you know, lawyers are there, but then is that it's good to belong to a professional body. For example, what we are doing at Social Enterprise Society of Kenya, we are partnered with Thomson Reuters Foundation, and all our members get pro bono legal services on copyright. So if you want to protect your idea, if you're a member of Social Enterprise Society of Kenya, CESOC, then now we push it to Thomson Reuters Foundation, and it's done for you.
Ah, fantastic. That's a good avenue,
Yeah,
Liz.
and I was going there. So we start with first the basics, yeah? Because when you're putting together a business, you have to decide, what am I spending on, blah, blah, blah. So legal has to be at the top. Then you figure out and say, you know what, I can only afford 50,000 for a lawyer or whatever, then have a conversation and retain them. If it's impossible, like he said now, be a member of some sort of an association and figure out you're together as a certain group of people with the same challenges and say, okay, we're going to be putting 100 bob every month towards legal, and then everyone has access to legal facilities and legal help. Because also doing pro bono work in legal can be quite tasking.
Yeah.
So unless you're in a huge foundation where they pay you as an in-house lawyer and you can do all these things for free, then so be it. But it's very few foundations and associations that actually invest in legal help. For, as far as legal is concerned, the approach has been it's your right. You decide how you're going to use it. And in business, they say they thrive on ignorance as well. So if ignorance of the law is also no defense, it's up to you to educate yourself and figure out. But I always say negotiate, approach lawyers. We are not hard-headed people. We are not cold-hearted people. There's a way you can engage.
Fantastic. A great conversation this morning, and definitely this could go on, and it continues on Twitter at Gladys_Gachanja at NTV Kenya. Thank you so much to Peter Oloo, CEO, Social Enterprise Society of Kenya, SESOC, Marsha Aida, Science and Technology Law Lawyer, Liz Lenjo, Intellectual Property Lawyer, and of course Daddy Owen, who is a gospel music artist and has an experience in being a former board member of Prisk. Well, the conversation has been intellectual property in the markets, the last show of the year. So thank you for your company. Let's continue talking on social media, and of course you can get in touch with my panelists. Have a great Thursday. My name is Gladys Gachanja.